let's begin with the vexed issue of Section 84, subsection 12 of the Electoral Act 2022. President Muhammadu Buhari and the Attorney General of the Federation and Minister of Justice, Abubakar Malami, have filed a suit at the Supreme Court seeking an interpretation of the contentious clause. It will be recalled that the Court of Appeal in Abuja set aside the Federal High Court judgment that deleted the clause from the Act, while also agreeing with the lower courts that the new provision is unconstitutional. Babajide, after this, we now, after the Court of Appeal gave the verdict, now we have, now have the President and the Attorney General going to the Supreme Court, which is the apex court, and this is like a constitutional matter. I'm sure it's going to be expedited. But let me quickly take this break. When we get back, we'll talk more. It's still Journalist Hangouts. We'll be right back. Please stay with us. Sorry for the mix-up there. Sam Ibemere is not joining us, for real. All right. Jide, this Section 84, subsection 12 of the Electoral Act, you know, it has been contentious. The President signed the Electoral Act 2022 as amended with the caveat that the National Assembly, please expunge these parts. And when it got to the National Assembly, the lawmakers were courageous enough and they said, no, we are not going to remove it. Now, we are going to have a final solution to this matter at the Supreme Court.
Yes, the President, it was a rare show of independence by the lawmakers. And on the day when they turned down the efforts of the Senate President to have the Senate revisit that matter, I've never seen a no voice vote as loud as that. I don't think there was anybody in the Senate chambers who wanted them to revisit that matter, because it was a resounding no, very loud. And the Senate President had no choice but to do the wish of his colleagues, because when your colleagues rise in a wave to say they don't want something, if you insist on having your way, they will eventually impeach you, and you then begin to lick your wounds. So they said no, that this was what they wanted. But as I said here a few weeks back, there are many people who believe that that portion is discriminatory. You know, that why should they disallow some categories of people from being elective delegates at party primaries. Now, the Attorney General is arguing that that portion is inconsistent with sections 42, 65, 66, 106, 107, 131, 137, 147, 151, 177, 182, 192, and 196 of the Constitution, the Federal Republic of Nigeria, as well as the African Charter on Human and People's Rights. So what they are there to argue is the fact that the rights of some people have been taken away by barring them from being elective delegates at party primaries. The argument of these lawmakers had always been that this gives governors extreme powers. Governors are able to hire up to 2,000 aides if they wanted. And if you allow all of these aides, some of them may not even be active party members. You allow all 2,000 to be delegates, to be able to vote at party primaries. That has already given a governor a big head start. So if a governor does not want a particular person, yes, even right now that's still the way it is. If a governor does not want someone, that person will not emerge. You know, so that the advantage that it gives governors, if this were allowed to go on, is what those federal lawmakers oppose. You and I know that these federal lawmakers are always daggers drawn with governors. In some cases, governors will be after their positions, so they frustrate them because governors want their Senate seats. So this is the situation. We can't pretend not to know why those guys opted for this portion. Well, Kaode Ajulo, who is the lawyer representing the National Assembly, is saying that the National Assembly has powers to make laws for the country and that the Supreme Court cannot delete a law that was validly made by the National Assembly. Well, we'll see what happens in the final analysis.
Now, we have this, these are our representatives. There are 190 members. And the president is now saying that alter this part, I'm going to sign it. A lot of people believe that if the president had a major issue with this section 84, subsection 12, that the president would have turned it down, would have not signed it now, than trusting the National Assembly members that please alter it, that it's quite unconstitutional what the president did, that once you sign it, it becomes law.
Well, I think it's all arguable. But you know, the beauty of what we're experiencing is what democracy truly represents. The president is bound by the Constitution, and that's the truth. And of course, he has advisors who will tell him that certain things, you know, contravene the Constitution. And I think what Mr. President did at that time was based on the advice he got from the Attorney General, you know, who informed him that certain sections of the Electoral Act, especially 8412, you know, was unconstitutional. And if you recall, what was done by the Attorney General then, even though it became, you know, a source of concern, was the hurried, you know, move to get the matter interpreted at the High Court somewhere in Abia State. And the ruling, the order that was given by the court was that it was unconstitutional, even though at the appeal level, it was found out that the person who moved, you know, for that issue to be addressed didn't have the local standing to deal with it. But even in the judgment in the opinion of the appeal court, they felt that if that matter had come before them through the right source, that their position would have been that it was unconstitutional. So what we're having is a test of our laws. Right here on this forum, we have always argued that, you know, or maintained that our courts should be tested. Issues like this and many others, you know, that are not very clear should go before the courts to get, you know, the right interpretation. And I think that the president did very well to take the matter, you know, to the judiciary, which is one of the arms of our democratic institutions, you know, to have this issue interpreted. So let it go as far as the Supreme Court, and of course the Supreme Court is going to have the final say on this matter, and then we can have, you know, clarity on what, you know, the law, you know, says concerning the rights of political appointees to stand for primaries, vote at the primaries, or be voted for. You know, I think we need that clarity, and there are so many other issues, you know, as I said, you know, which clearly indicate that we have gaps, you know, in our laws. Maybe if we have time, we can dwell on some of these other gaps that we have. But it's fine that we are having some of our laws tested, you know, at the highest level for clarity. Once it is done, it's done.